If my personality was a Kenyan meal,
I guess mocha.
why by the
It's mocha kioko, bro.
tell me why. Tell me why.
I feel like also Jerry mtu mwenye he's either your cup of tea or he's not
completely.
Yeah, like you're either obsessed with mocha and you can have it every day
or not completely.
Else you're like
Mr. Geoffrey Rigathi Gachagua. I think it's proper for me to give you a brief background of the case. And this happened after the fallout between the president and the deputy president. And then in 2024, subsequently in October, Honorable Mwingi Mutuse went to parliament and moved a motion. It is a very important case, especially for constitutional law classes, but also for the general jurisprudence of this country. They will need to have adjourned the hearing after the former DP was pronounced sick. Therefore, he could not attend the session that will be cross-examined. I don't know what we think about this case, but I've heard people give it different names. I heard someone say judicial nonsense. I heard someone say mediocrity. I heard people say it was a predetermined fate. It was almost obvious that state had something to do with it.
Overturning the impeachment might not necessarily equal the reinstatement of him as the deputy president. Many people have been debating and throwing their opinions online. This issue of CCTVs in public places. Is there a law that guides us? Because many people are feeling, say they're just infringing on our right to privacy.
This is Law in the Neighborhood podcast. Brought to you by CH Studios, creating content that connects.
Yet another amazing opportunity we collide here. My name is Colines Collines Muyeku, but you can always opt for CM. This is Law in the Neighborhood, your go-to legal talk show where we get to dissect legal intricacies for the common mwananchi. As usual, I'm always joined with the beautiful team of future legal eagles. We have the full gang in the house today. But before we proceed, as usual, I'd wish to say thank you to our premier production partners, CH Studios. CH Studios, we create content that connects. We're located along Wayaki Way at Almond Park. Please feel free to reach out to us. We are going to connect you to the best state-of-art facilities. The house, the gang is around. Niha, Jaga, Wagwan. How you doing, man?
I'm doing great. Just for the sake of it, my name is Jerry Amimo George Ambuche, but you can always call me Jaga. And I'm very excited for what this episode has in store for us today.
Interesting. Niha?
Minkopoa. My names are Niha Chege, and I'm excited to be here.
Nice.
Yeah.
Before we go on, last time when we had an icebreaker, you guys couldn't guess the correct answer for what crime I'd be charged for. So I'll still have you do research, and then the next episode you'll tell me. But for this one, I have something else I want to ask. It is random, so random. It is random. And it is courtesy of Jenny. So, if your personality was a Kenyan meal, what will it be and why? I'll go first. I think for me, I'll go for like a proper Kenyan meal, ugali na mbuzi. It is classy, but not also classy. It is just like hapo katikati. But also where I come from, the precious plant that must always be protected, the maize plant. It subsequently makes me love ugali automatically. So I'd opt for that. Jerry?
If my personality was a Kenyan meal,
I guess mocha.
Why by the...
Smocha Kioko, bro.
Tell me why. Tell me why.
Because Jerry seemed to unaweza predict.
Yeah, I feel like
Unaona
also Jerry ni mtu mwenye he's either your cup of tea or
He's not completely.
Yeah, like you're either obsessed with smocha and you can have it every day
Or not completely.
else you're like
You remember PK
Kwanza,
saying
I
smocha?
had a lecturer hakuna kitu alikuwa
Chikia
hapendi kama smocha. Like
So Jerry tutakupea yako.
Profiling.
Nyiha.
let's first hear what Jerry is from his
I can
own.
guess
Nimekubali matokeo.
Umekubali. I feel like yangu ingekuwa probably any potato dish. Sana
I knew
fries.
it. Oh.
Na maybe a side of chicken. Like fries na kuku.
Sema tu waru.
Waru, heavy on the waru. I feel like waru is so like waru inakuanga underrated. Like unajua vitu unaweza fanya na waru. Like waru is so goated. Like you can do anything with waru. Actually, waru makes me happy. Like I can't even express. By the way, nimekula waru from last week. Almost daily.
Hey.
Oh
Hadi
my.
nikienda kununua na shanganga. Mtu niuzia kwani yeye ni judge kila siku. Nieke waru za so. Nieke.
Interesting.
Anyway, yeah.
That's a by the way. Anyway, let's get into now the episode. But before we go in, if you haven't subscribed to our channel, we've realized most of you engage with our content, but you've not subscribed. Please go ahead and click that subscription button. That's the only way you can show us love, and also share the same with your friends. Into it, this week we had an interesting decision passed. I had the privilege of being there in person. I actually fought for a seat to be there to listen to that case. It is a case that almost every Kenyan was anticipating to get what the court had to say about it. Of course, it is the impeachment case of the former deputy president, Mr. Geoffrey Rigathi Gachagua. I think it's proper for me to give you a brief background of the case. And this happened after the fallout between the president and the deputy president. And then in 2024, subsequently in October, Honorable Mwingi Mutuse went to parliament and moved a motion to impeach the deputy president on 11 grounds. And subsequently, the motion went to the Senate, and the Senate approved 6 offenses, therefore moving on with the impeachment, but left out the 5. And this now led to the High Court coming in. And we had 3 judges presiding over that case, Justice Anthony Murima, Freda Mugambi, and Justice Ogola at Milimani Law Courts. But interestingly, this case caught Kenyans in a tough situation because we're in economic crisis, and we are also in political crisis. The case came in, and it's so important because it is changing the jurisprudence of this country, right? It is a very important case, especially for constitutional law classes, but also for the general jurisprudence of this country. What was so interesting in this case, it is one particular charge that the court spoke about it that struck almost everyone, that the Senate was found to have infringed Article 50 by not giving the deputy president a fair hearing, because they will need to have adjourned the hearing after the former DP was pronounced sick. Therefore, he could not attend the session that to be cross-examined. So we saw a court balancing this, that even though the right to fair hearing was infringed, it does not matter enough to disqualify the whole impeachment process. It also said that the impeachment process of a Senate is final. but also subject to judicial review, and that's why the court pronounced it has jurisdiction over that matter. So Kenyans are debating here. My right has been infringed. And then you go ahead and say you're not overturning the impeachment. But the court reasoned, if we do overturn the impeachment, then it means we have 2 sitting presidents, deputy presidents in the office. And if we have 2 sitting presidents in the office, deputy presidents, that is a clash of titans. I don't know what we think about this case, but I've heard people give it different names. I heard someone say judicial nonsense. I heard someone say mediocrity. I heard people say it was a predetermined fate. It was almost obvious that state had something to do with it. But what do we think about this case, and what do you think it is adding to the jurisprudence of this country? Maybe I'll start with Nia.
First of all, I think it's very important to look at the motive of the impeachment. Was this impeachment a constitutional move, or was it a political move? And we see that in the Constitution of Kenya, I think it's Article 150.
Yes.
It has given grounds for the impeachment of a deputy president. And the law is very interesting, especially in Kenya. It's like we have a law for every particular scenario, but we still have conflict. Because I found that there was an impeachment act and an impeachment procedure act of 2018. Either way, the question is just to understand whether this is a constitutional or a political move. And when you think about it, the article 150 of our constitution gives particular grounds. But we find that different players in the government have different roles. For example, the parliament, where the procedures were initiated, we also have the Senate, who are supposed to conduct the procedure, the hearings, and everything.
A trial.
And the funny thing is, this particular procedure is given in the law, but the law does not address this political, like the political motive behind it, because the law has given the procedure. But when you look at it, is it evidence, or is it the political numbers that will give the final decision? Because at the end of it all, the people in the Senate are political representatives.
Yes,
when you look
they're
at it.
politicians.
So when you look at it, the law will say, for example, it talks about gross violation of the Constitution. What amounts to this gross violation? The people who are to determine that are people who are political players. So it is very important to understand that we can't say the case was predetermined, but you must look at it from various angles. Like there are a lot of questions that, has this followed the law? Has this violated this person's rights? That, like, there are a lot of questions in play. And I think one of the main things that was brought about was the right to fair hearing.
Yes.
Yeah, Honorable Gachagua was not given the right to fair hearing. And I think, I don't know, that's an issue to be determined. But I think that we should not be blind to the fact that this had some sort of political motive. And I feel like there's also a question that many people, they don't understand what is the real reason behind Gachagua moving to court.
Yes.
Is he seeking reinstatement? Is he seeking damages? Is he seeking... And as of today morning, I was scrolling and I saw he said it was never about the money. So
what was it about?
I think I'll just leave it to his lawyers.
His lawyers are my friends.
To explain this whole... Personally, from my own perspective, I think Niliacha, I just stopped looking at it from a biased point of view. I'm now looking at the different angles, because...
You're being neutral.
Yeah, like I'm being neutral, because if he's reinstated, what happens next? But still, he has his own rights, which when you look at his arguments, like it makes sense. So right now I'm just waiting for an outcome, and then
The Court of Appeal.
nikae sasa chini, and then maybe after that I can form my own opinion. Though it's a very interesting scenario. It actually helped me see that our law is very detailed. Like
Yes.
it has tried to highlight and give a solution for problems which might arise.
Yeah.
So
Flexibility.
yeah. So that's my particular opinion. Like it's as much as it's a constitutional issue, I cannot be blind to the fact that it has some sort of political motive. So yeah.
Jerry, what do you make of this?
No, I was just sitting here listening to
Nyiha.
the wonderful views.
Give us your beautiful words.
Mine might not be wonderful. Si mnakumbuka mlisema mimi ni smocha. But yes, I think for this particular item, the law hasn't really provided each and every provision as to what really is to happen. It's not like a governor's impeachment where there is an act that guides it. For the president and deputy president, it is solely tied on constitutional finality, such that the constitution cannot in itself give provisions for everything, but it must be interpreted in such a manner that it has given provisions for everything. So that now leaves the judiciary with freedom to try and see how best they can balance it. So what we saw on June 8th was the judiciary trying to be a surgeon, the patient, the constitution. Because it's trying to balance.
Yes.
Your point on the dual incumbency absurdity. Overturning the impeachment would in one way mean that there are two deputy presidents.
Yes.
But
simultaneously.
if we go back to what was raised by Nyiha, what is Gachagua's goal? Overturning the impeachment might not necessarily equal reinstatement of him as the deputy president. It will only mean if it is overturned, the deputy president, the current one, was already appointed, so that is overtaken by events. So overturning the impeachment will now then mean he can vie for a political office, and that, I think, majorly was his goal at the end of the day. It was never about becoming deputy president again. And maybe if that would have happened, if the impeachment was now declared unconstitutional and unlawful, we would have seen a higher amount of damages offered, higher than the 50 million he was given. Because the 50 million only equates to his right of fair hearing, which he was denied. So now you can see the High Court trying to play safe.
Yes.
Trying to avoid a decision that will create a vacuum or adjust a weird constitutional position. And that is why they opted to say, although your rights were infringed, it doesn't go to the extent of
nullifying the whole process.
The whole process. That is how we see them arriving at that decision, is to avoid very weird constitutional positions or outcomes. Though I had someone joking on Twitter, now this is very nice. We are waiting for the outcome of the appeal in 2027.
Let me read
Supreme Court in 2029.
Let me read you that. That is Dr. Miguna. The court has cooked regarding Gachagua. 2 fatal findings on public participation and bias have sealed his fate. But I believe the court's finding on these 2 issues were implausible and incoherent in view of the evidence before them. we will wait for the decisions of the Court of Appeal in 2028 and the Supreme Court in 2029.
He was drawing shade, some shade here and there.
Who loves Miguna as I do?
I usually think he's actually quite hilarious.
He's all over the place, literally.
And I don't even know how he keeps up. Because after 5 minutes, whatever happens, you'll find his tweets there with a very... You even wonder, like... You know.
Then we can go back now to the doctrine of the political question. Impeachment is a political process. It's not a legal process. And so you can't say that there was bias. Even the court acknowledged that the bias allegations here are unfounded. They are just assertions which were not proved. Because for you to prove bias in any court of law, it has to be real and not illusory. It really needs to be clear that this is bias.
Yeah,
you
this
can't
is
just say
bias.
because this person held a rally in Turkana and said 2 weeks the deputy must go, that's bias. It's more than that. Then now finally on constitutional finality.
I think before constitutional finality, when you've said impeachment process is a political process, I think that is what Professor Githu, a good friend of mine, argued. But I was listening to this Wakili, Daniel Manzo, and he was saying, you see, we can only have 2 types of trials. There's either criminal trial or civil trial. But the impeachment process falls at the middle. That means it could, when it comes to evidentiary proof, you see, in the criminal aspect, we have the proof beyond reasonable doubt. And then for the civil, it is on the probability. But for the impeachment, it is now balancing the two. And that's why it's not really a legal process, as we might say, for the court session. And I also had someone argue on the fair trial part that, you see, sometimes if you have a lawyer, they'll appear in court, you might not appear, right? So what they were arguing is that before the Senate, all the documents that were required to be there were there. So Gachagua's lawyers being there, it didn't mean that the person accused wasn't present, because the documents to be used to make the findings were already before the Senate. So it is an interesting area to argue from, but I'll leave it to you to go back to the constitutional aspect as we finish up the courtroom.
Okay. So yes, even before we go to finality once more, some of the arguments on public participation
Yes.
around the impeachment of the deputy and also the appointment of the new deputy.
Interesting.
So now we are going to link it as we enter constitutional finality. The constitution doesn't mention anywhere that those 2 processes require public participation.
The impeachment.
Yes.
Yeah.
And the appointment of a new deputy president. And that is where now constitutional finality was a factor in determining the outcome of the case before the High Court, in such that the main arguments of the petitioners were founded on something that is not clearly stated in the Constitution, or they didn't argue in such a manner that directs the court to interpret the Constitution to align to their arguments. Hiyo sentence ni refu kidogo.
I'm loving the way you're arguing. We're gonna argue kama the lawyers were state.
Ndo nimeona.
It's really for the state.
No, I'm for the balance, the balancing point.
I'm seeing you.
Yes, rights were infringed. The right to fair hearing was infringed, but we are in 2026.
But
we have a new deputy.
Jerry, you have to go back and see that a deputy president is elective position, and 7 million Kenyans voted in this deputy president.
Yeah.
So for you to remove them without consulting those who put them there, it is you sidestepping the sovereignty of the people.
But
and that's why
did
they were
the
arguing.
citizens choose the deputy or they
Or
choose the president?
When
But,
you're choosing the
you know-
presidency, you're choosing the deputy.
Let me
Can a
tell you.
president run without a deputy president?
For example, I was talking to some of my relatives, ile kitu ya nyindo mlituwekea Ruto, like that whole conversation you have with your parents. And some people told me they voted in Raila. Back then, they voted in Raila just because of Martha Karua. Like, there are people who only, especially watu wengine what do you call them? Wamurima. They only voted this person in because ukiangalia unaona Gachagua wetu hako hapo. So
Tick.
so
How the
by
millennials na baby boomers?
wengine hatuwezi wa categorize, but by you there are people who voted the president in mainly because of their deputy. So we can't also be blind to that fact.
Okay.
No.
Now, linking to constitutional finality.
Yeah.
Yes, the argument is there that this person was elected by the people.
Yes.
But if you look at the clauses of removal of a deputy president, the grounds and the procedure, solely tied, the grounds are provided there, and the procedure starts at the parliament. So even if there were to be a provision on public participation, I think the framers of the constitution would have placed it there or written that part in such a manner that it will be interpreted as if public participation was needed. Because you see what happens at the parliament now in an ideal vacuum and working state where everybody is doing their job. I'm not saying Kenya is one or is not. The MPs are supposed to be representing the views of the constituents hapo. So you'll find that what the MP is saying basically is supposed to translate to grau inasema nini.
That's the thing.
But most of the time it's definitely not
the
it.
case.
And even if we were to argue public participation, do you know the tests for public participation? It's not definite. And then the court can't say this was public participation, this was not. It is from a case-to-case basis. Best example is when I'm conducting public participation, I roll out the format in which you're supposed to participate and you don't. Like we roll out to all Kenyans and only 2 conduct their public participation right. Many will come and say 2 out of millions, that is not sufficient. But during that time, when they called for it, nobody really reacted. So the test is applied from a case-to-case basis. So for this particular one, before we start mentioning whether there was public participation or not, have we looked at the intricate details that inform this case?
Which are?
Was there a forum that was established but people didn't just see it as an issue to respond to at that time?
We actually had
Or was
200
there not?
200,000 people are the ones who participated. And I was just looking at when they were doing estimations, it out of 54 million Kenyans, let's just say that is when I was listening to the arguments of the petitioners, and it was turning to 0.001. So it means barely no one participated. But it's okay. I think the court said on the public participation, it's not really about numbers.
Yes.
Yeah.
Substantiability, not
Qualitative plus quantitative
That's the thing.
analysis
Yeah.
is going to be considered whenever we are talking about public
public. So it's not about numbers really.
Yes.
But anyway, I think
And
we
as
can
long
hear.
as the government agency can show effort and commitment that indeed this public participation was real, it was purposive. Those are some of the things that the court will consider. So sisi watu wa court of public opinion.
Anyway, I think you can see where Jerry lies. But anyway, I'd want to hear from the neighbors as we finish up in the courtroom. There's something. Is Gachagua eligible for any political seat as he aspires to be a presidential candidate? Do you think he's eligible? And if our tedious, our long court processes go on, because we'll be having an appeal, who's really benefiting from this? Is it Gachagua? Is it the state? Those are some of the questions to be asking ourselves. But I think it is our good friends. And that's why we usually say there's no any other career like law. You see? No kama hapa vile. Naambia tu
Don't do law.
Naambia.
I'm a common mwananchi.
But a lawyer. But anyway, that's it for In the Courtroom. Engage with us. Tell us what you think about the impeachment. Do you think the case was predetermined? Do you think it was politically affiliated? Do you think you agree with what the High Court said in the 350 ruling? We'll end in the courtroom at that. I'd now have Jerry tell us what he has for us, the legal bulletin. That is what I got when I was walking through the corridors of justice.
This time you went.
This time will you walk through the corridor?
This time you went.
I was there, man. I passed through them. Anyway, Jerry.
So on to the legal bulletin. Mm-hmm. So many people have been debating and throwing their opinions online. This issue of CCTVs in public places. Mm-hmm. Is there a law that guides us? Because many people are feeling, say they're just infringing on our right to privacy. But worry not, as we are going to be discussing that over the next few minutes. So CCTVs, yes, recording people for security purposes. Mm-hmm. So I guess the whole conversation starts from the right to privacy as captured in our constitution.
Article 31.
Mm-hmm. But they just a side note. Uh-huh. Do you know America's constitution doesn't have the right to privacy, yet people argue that they protect privacy better than us.
Actually, we'll be discussing
who actually
that. Yeah.
have a clause on data
right.
privacy.
Even a whole
in our
act.
Constitution. So
yeah.
Interesting things.
It's studying law.
So the conversation starts from the point of your right to privacy, which is protected under the Constitution. And yes, you have that right not to be surveilled. Evil too. Like I can't just start following you. Oisinita kwako, then you have hidden cameras everywhere, then that you're infringing on my right to privacy. So
kwangu.
Hiyo ilikuwa ya target audience fulani wanaendana Kilimani, but that's
a discussion for another day.
Hey, that's a discussion for another day.
At Kilimani. Very specific.
If you know, you know. So yes, from that we start. Where can really CCTVs be placed, and what does the law say about it? Mm-hmm. So we can start from the right to privacy, as we already did. That right is guaranteed. 1. 2, that right is not absolute. It can be limited.
Yes.
But from our previous episodes, we've been trying to show you how rights are limited. Rights are limited only by law, and if it's necessary and proportionate and reasonable. So I can't just say, as the president, niamke tu siku moja niseme sasa kuanzia leo tunaangalia M-Pesa ya kila mtu. na tunataka
Kawa naangalia alafu anajaza.
Anakuhurumia quality ya 3 bob.
I don't mind.
so there has to be a certain law supporting that limitation through maybe an act of parliament. That's why we have the Data Protection Act
2019.
yes, and maybe we have also the National Police Service Act to guide even how they're supposed to be investigating you and how now they can limit your right to privacy. So it's only done by law, only limited by law.
Yes.
So that is aside. So now we jump on to data privacy through the Data Protection Act. Whenever somebody is taking or collecting information, directly or indirectly, it's okay. Directly needs your consent. Indirectly needs a notice that indeed
Yes.
your data is being collected. In this sense, a video of you is being captured. Have you ever gone to these public facilities, then unaona hapo kwa CCTV smile on camera? You see the notice is usually on very noticeable places. At least you know
CCTV surveillance.
CCTV is capturing you. But people might argue, sasa mwizi amekaa mshamwambia kuna CCTV. Ashajua. Is there security?
Blind spot.
Is there really security there? But now that is only one aspect of it. So mtu atakuja mwenye si mwizi, you know you are infringing their right. So it's an interesting argument by the way, because even parents, I'm sure if they are putting CCTVs to monitor their children, hawatawaambia that wameweka. So kama mzazi wako you have reason to believe amekuwekea CCTV, unaweza nipigia tuone
what you can do about it.
Utachapwa na pia hajachapwa.
So now this comes at a crucial point.
Yes.
Especially in our country. By the my schooler, unaweza waona mko home. And you should listen to this before.
Very important.
So that any decision you make past here, at least you know
it is informed.
It is informed and objective. See mass behavior. So there's this recent order by the CS Interior that each high school should have CCTV cameras. But you see, in Kenya, there is no legal framework or policy that guides how CCTVs should be placed. We are just using the right to privacy and the general data principles captured in our Data Protection Act. So one may ask themselves, nimeshanunua hii CCTV, sisi kama X and X, boys high school, how should we place them or where should we place them? So come to think of it. So hapa ndo tunataka to brainstorm as a neighborhood, as law in the neighbors.
Yes.
What do you guys think? How should those CCTVs be placed? You know, here we are also doing representative democracy. So maybe Collines or Nyiha has the same view as you do. So maybe you can tell me or tell the neighbors. What do you think? How should these CCTVs be placed?
I think first, let's create the context. I think it is coming when there's unrest in our schools, in our high schools, and some are affiliated to that, which is so unfortunate, right? But if we now go back to the aspect of necessity, you see, I'll give you an example. In our school, I think we have CCTVs in class. So I think there was a student who was studying, and then she collapsed. And the only reason she was saved, I think she had, was it asthma? I'm not sure. But the only reason she was saved, it's because the person who was in the control room was able to see the student is collapsing in building X and X. So they had to rush there and take him the ambulance. I'm just wondering if there wasn't a CCTV, kulikuwa na shida. So I'm looking at this from a point of necessity, in the sense that, say we are putting a CCTV, let's just use the dormitory, right? You see, I'm not staying alone. Sikai peke yangu kwa a room. I'm staying with my other students in this dormitory, right? And therefore, the question now will be, does this now become a public space, or is it a private space? Are you seeing? So that is the first question we should be asking ourselves, because I'm not here peke yangu. Nope, I'm here with other people. But now the second thing is, what is this? This is a dormitory. What is it used for? Number one, after nimetoka kuoga, this is where I'll be changing my uniforms from. This is where I'll be doing my personal cleanliness from, for the ladies, the grooming and all that. So to some extent it amounts to some private space. But siko hapo peke yangu. Niko na 400 other students. I might not really know Mia's motive, your motive and stuff. And that's why it necessitates for us to have CCTVs in such places. And we go back to Article 31, right to privacy. And then we now come back to Article 25. We have non-alienable rights. And then we have to ask ourselves, is Article 31, right to privacy, one of the rights that cannot be alienated? I think it's not, right? And then we now ask ourselves, is it limitable? Of course it is. And it has to, pass the criterion put there. So to me, putting CCTVs in a hostel, it is a matter of necessity. I'll give another example. I think we had a school that I won't name again. I think we had a case where a student also was I don't know, due to mental health issues and stuff, and then they stabbed themselves. So if there wasn't a footage, of course. So Apo 2, it's just having theories and theories and theories. But if we had, we could have at least established a motive. We could have seen what was going on, background and stuff. So I think for me it is about the necessity aspect, that we do need these for the safety purposes. Kama tungekuwa tunaaminiana ingekuwa sawa, but hatuaminiani sisi kama wa Kenya, hatuaminiani. If you go to China, I was seeing a BBC documentary. In China, literally all over the streets kuna cameras, like the state monitors you. Ukipark tu gari kidogo tu hivi, place unnecessary uko ndani. So I think to me it is a matter of necessity, but also respecting that if it is a ladies hostel, then it has to be ladies moderating everything. If it is men, it has to be men moderating everything. Yes. Yeah.
Okay, the whole issue of privacy and surveillance, it's a very multifaceted issue. Let me just refer a bit to, for example, the Utumishi Girls tragedy. That particular CCTV recording is a key piece of evidence. But there are two uncomfortable truths arising at once. Number one, was the privacy of these girls infringed? And also, it helped to shed light on the situation. So it also brought about the issue of security. So, and I think both of those things can coexist at once. There was a time I was seeing people on Twitter were asking that particular issue of privacy, and people were attacking them. Like, why are you asking about privacy while people are dead? But it's also a concern, because who is behind this particular CCTVs? These are girls.
Yes.
Apo, it was in a dormitory. You could see the inside of the dormitory, meaning that's a very private space for those girls. They do their things there. So who in particular is accessing that particular footage? But I think our Data Protection Act has tried to shed some light about data collection principles, like the purpose. For example, what do you need this data for? Access, who is accessing this particular data. Also, it sheds some light about consent, like informed consent. You actually do know you're being recorded and stuff like that, or you can even be sent a notice and things like those. So I think it's a very multifaceted issue. And sasa the issue is, it's like these two goals cannot coexist at once. You want to place a CCTV for security, but the placement is also an issue. Like, do you get where this conflict is coming? Because you
that's
want,
why I said necessity.
yeah, like you want to see what happens, for example, in a bathroom, but also does it make someone does it make someone feel comfortable? You know, sasa issue pia ya dignity also comes in, because kuna two place you can be monitored and it strips you of your dignity. You can't even exist as yourself. So I think even as we place those CCTVs, even as they follow that particular directive, they should try and analyze it in both particular angles. You know, like, yes, we want to safeguard our students, or yes, we want to safeguard our business, anything. But also, is this like, does this infringe on the right to people's privacy? And maybe they should also give notices, hata to the students. You're being recorded. You're being monitored.
Valia uniform kwa blanket.
Like, you're being recorded, you're being monitored. And I think also they should address the issue of access.
Yes.
Who is going to access this particular footage? Who is going to access this, whatever is happening? Because, you know, sometimes there are people who are like prominent, wanaenda mahali mwenye ako huko kwa access anapiga simu ako hapa kujeni mfanye ile mambo. So it's an issue. It's like a very multifaceted issue. And I think in addressing the safety concern, the concern about privacy should be inafaa pia ifitiwe hapo. Like, it should be an approach that recognizes the safety aspect and the privacy aspect. I don't know.
Najua kuna mtu atasema but ni black and white. But like, bado tunaona.
It's a very complicated issue, by the way. Unakaa chini unaifikiria unaona. Hao watu wa privacy wana make sense.
Yeah.
Lakini tena ukiangalia, you know, kitu yako ikipotea place hakuna CCTV, you start
that's
asking,
when how
why
you didn't have safety measures.
Why didn't you have this? Why didn't you have this? Why was this not there? But also, ikiwa time it's your rights,
ndo unaanza kusema
I know my rights. I feel like our law has tried to
balance.
Yeah, to balance. It has tried to balance both.
And you can't have it both ways.
Exactly.
At least one has to win. Gachagua too. No. One has to win. Anyway, Jerry, what's your parting shot? What are you telling high schoolers? Wakubali CCTV ama takwaje? Don't incite them. Remember, what can you be charged for? Sedition.
But there you can watch that video and see where that sedition is coming from. So, for me, I'm just going to outrightly say it. We can't have CCTVs in private and personal spaces.
Yeah.
In any
form
of setup.
So hostels una.
So it depends. When you're putting it on the hostel, you can put it
along
highway. Dormitories along the hallways.
Yeah.
And at the entrance and exits of this particular area. So even when you're doing investigations, it's more of like, we can see this person entered this area this time, exited this time. And that goes a long way to try and place you at the scene and also to prove other things like motive and actually the actual deed. And that's why I usually say, no matter how technology becomes advanced, we need human input. Do you know that piece of evidence, your hallway, at least you can see the entry exits, now buttressed by a guard who was actually there.
Yeah.
Who can now narrate the story. So it becomes an area. The major problem we are having with how we are going to place these CCTVs and address the right to privacy is that people want the CCTVs to do the entire of the work.
Kila
kitu.
Ione kila kitu, yani ijue
ile inafanyikia gizani.
But
lazima ibaki huko.
You know, there are some areas the CCTV can't see because of now the right to privacy.
Yeah.
As you said, if you're having it in classrooms, that's okay. That's not anyone's private space.
Yeah.
Do you know, even working spaces, you can put CCTV. It's not your private space and personal space. But now washrooms, where people change, where people are basically even sleeping.
Yeah.
Yes, that is where the scope of that CCTV, if it sees, I believe that is infringement of the right to privacy. So implementing and complementing human efforts and computer efforts will easily solve this menace of how to place and where to place. And then also additionally, if you're a high school, they are struggling to come up with a policy of how to place CCTVs, you can always reach out to us.
A jack of all trades. Law is not paying that well.
You can always reach out to us for further insights. So my final parting shot to the scholars is the right to privacy exists and it's there.
But it's limitable.
It's limited. And on the issue of CCTVs, it can be placed at various areas around the school, but never, and you should not allow it to be to be placed in private
He's
places
making a nice
like
point.
washrooms where you are changing
Yeah.
and so on. Classrooms, that's okay. You hadi usipigane. But hadi ingine sijasema upigane, but at least you can do it diplomatically. We
Watu
have
wakulala class mazee.
You know, it's this whole CCTV like saga inanikumbusha watu high school, they do things aduna shanga. When I was in high school, there was a person who stole money from a whole class. Na mtu alikuwa amejifunika sheet ya white. Imagine the only evidence the school had was the size of that person's nails. Huyo mtu alikuwa anajua hadi blind spots za CCTV. Alibia class mzima fair second last day.
But you see, where were the watch? Where are the security guys?
We were like, huyu
Nails.
sasa nails ndo zilionekana kwa CCTV.
Peke yake.
Alikuwa amevaa ile ka ghost, ametoboa tu macho.
Ghosts do exist.
Nini akaiba class mzima. Yani
Ulibiwa wewe?
mimi si kwa hiyo class, but hiyo story kitufikia, alafu unajua as the story goes inakuwa manipulated. But wherever that sharp girl is sitting, sharp girl,
La Casa de Papel is coming up season 6. She must be featured in. Anyway,
it's so interesting.
It is.
Yeah.
Anyway, that is it for the legal bulletin. Now, Tombie, today, what do we have? What is that legal fun fact that you ought to know today?
So for today, I got very curious. How long is our constitution, and what does this mean for us as Kenyans? And as I was researching, I found out that our country has approximately, our constitution is around 48,000 words to 65,000 words. Very lengthy. And we have a country like Monaco. It has 3,500 words.
3,500.
Peke yake. And then the most shocking one was the USA's.
Amesema AI.
Ali prompt to in no more than 3,500 words.
But no. I take back those words.
No more than 35. Give me a constitution. Either way. So we have Monaco with one of the world's, I think it's even the shortest constitution in the world. 3500. Yo unasoma na unaingia exam. Mbona Kenya wangefanya hivyo? Najua article 1 to article 15.
Sasa hiyo hebu tuone articles ni jina tu moja. Right to privacy, privacy tu.
Like ni detail but si kama yetu ati article 24 sasa iko na 1 2. And then the one that shocked me a lot was the USA's constitution. It is a bit shy of 10,000 words. Around people estimate it from around 6,000 to 9,000 words.
A big country like that.
Kama kuna a country enye iko na developed laws ni the USA. Like, they have things for everything. Talk about anything. They have that law. They have that law. They have that law. So I wondered, like, does the length of the constitution of a constitution of a particular country make it more efficient, or does it make it as detailed that you'll, like, it's so comprehensive that hamtakuwa mnajipata in a place where you don't have a law that is addressing a particular situation? And maybe what informs the writers of the constitution to make it as detailed as they do? And I saw that for Kenya, tumekuwa na a lot of, in our history, we've had a lot of power struggles.
Yes.
We've had a lot of people waking up, amending the constitution. We are a multi-party. Like, we have had a lot of developments until where they finally promulgated the new constitution in 2010. And as I read, I was like, you know what? Maybe our constitution is as lengthy. They tried to make it as lengthy to avoid those particular situations that we had in the past. But also, when you look at it, sometimes it's usually so rigid that, like, it's so stuck that you can't interpret it. You can't interpret it in a unique way according to each and every situation. Like, imebaki tu hapo, iko stuck.
Static.
Yeah, it's static. And we have the constitution. For example, the USA's constitution. You find that in its constitution, it just gives basic principles. The legislation and the courts will interpret it as time goes by. For example, let me use discrimination, Article 27. Utapata, our constitution has tried to outline no one shall be discriminated on grounds of sex,
Age,
gender,
marital status.
Yeah, like they've tried to give
Marital status.
kuna hiyo?
Yes.
Oh, there is.
So single.
Like
Kama
them-
mimi, I'm single.
We shall not discriminate you. And also now there's like, the US has, I think it's the fourth amendment, it just has a clause, that an equality clause. No one shall be denied rights. Like, it's just a clause like that. And you find that that clause, it has helped sort out racial diversity. It has helped sort out gender imbalances. It has also helped sort out things like, even nowadays, what's an issue we have? For example, things like same-sex marriage. It has made it that people can run to court with that particular clause, and the courts and the legislators will interpret it in a way that it does not infringe their rights. It makes them have equal treatment. So that was just a question,
Interesting.
whether a detailed constitution makes it more efficient,
Or
what might make the constitution writers write a very lengthy constitution and such. Yeah.
I think on that, so we have countries with Monaco, the shortest constitution. We have Kenya, 48,000 words. Then we have UK, unwritten constitution. So it leads to one question. It's not, I think for me, I'll view it as, it's about constitutionalism. Oh, why? What am I saying? It is about constitutionalism. Yeah. We've seen many scholars argue that Africa, I'm sorry, I have a bad view. Africa is a continent with constitutions without constitutionalism. Because a country like UK doesn't have a written constitution, but they do have constitutionalism. So do we respect our lengthy constitution? Do we... Also, it goes to the way you say the history. I think it is also another thing of not having lacunas in the constitution, trying to address everything that might happen in the near future. Say, for instance, Kenya currently does not have any laws on LGBTQ, right? But we've had the LGBTQ community go to court and they argue using Article 27. Do not discriminate me, are you saying? So I think that is what I view it from. I'll stick to constitutionalism. Whether it's long or not is a matter of if we do respect what our supreme law says. Jerry?
I think that is one area I totally agree with you. Mm-hmm. But because I'm usually very abstract, I'll try and view it from this particular point. There are things when you're comparing maybe numbers. When you're comparing numbers, there is the issue of causation and correlation. So as Collins has said, the length of the constitution doesn't cause whether you're going to follow it or not. But people correlate that. They say these countries with shorter constitutions are actually following it because they are dealing with those figures in a vacuum without considering other qualitative factors like constitutionalism. Mm-hmm. So constitutionalism is actually what we should use to gauge it here. So yes. It doesn't actually depend on the length. It depends on whether this country really has constitutionalism or not.
Yes. I think that now leads us to the end of this episode. I think we've had an interesting episode from what is going on with the impeachment that is trying to shape the jurisprudence of this country, from what is happening in our high schools, the unrest and all that. But we were handling one area to be specific, the data privacy aspect. And then for the fun fact about law, that Kenya has one of the longest constitutions, and we have other countries with a constitution yenye hata ifikii sei yangu. Let us know what you think about all these, our neighbor. Engage with us. If you have not subscribed, please show us some love. We'll see you some other time. This has been a nice episode. Please keep engaging with us. Share, tell a friend, tell a friend. We'll see you some other time.
This is Law in the Neighborhood podcast.
Brought to you by CH Studios, creating content that connects.